Did you know that Aretha Franklin died in 2018 with no estate plan, leaving her sons to struggle and fight in court? I'm Varvara Gokea, the founder of the Inheritance Lawyer, and we created the Inheritance Audit Meeting because we want to help people protect themselves, their loved ones, their assets before it's too late. In this video, I'm going to tell you a little bit about Aretha Franklin's passing. You might have heard she died at the age of 76, battling cancer. What you might not have heard is that her 4 sons are still fighting it in court and trying to settle debts with the IRS and many other issues. Aretha Franklin could have helped her loved ones avoid all the court battling and the headaches and trouble and spending hundreds of thousands of dollars and many years in court if she would have set a proper comprehensive estate plan. There are a few points that I want to mention about this case. First point, Aretha Franklin was too late to meet with her attorney. When Aretha Franklin died, they found 3 wills in her apartment. They were handwritten wills, not executed, not signed by witnesses, not notarized, so they weren't properly created under the rule of law. A few weeks later, a law firm came and produced a 4th will, which again was not executed, was not signed by Aretha Franklin, was not witnessed, was not notarized. So again, it didn't follow the rule of law. Of course, Aretha was sick and she postponed meeting with her lawyer. First, she tried to do it on her own, and then when she realized the complexity and the issues that she had to solve, she went to meet with a lawyer, but it was too late. If Aretha Franklin would have followed up with her law firm, many of the troubles her loved ones are going through would have been averted. Point 2. All Aretha Franklin's assets are now awaiting a judge's decisions. All her assets are inaccessible to her heirs, to her 4 sons. Even if one of Aretha Franklin's wills will be considered valid, her assets will still not be available to her heirs, to her 4 sons, because of the large tax due that she owes to the IRS. When Aretha Franklin died, the IRS claimed that she owes $8 million in back taxes from 2010 to 2017, income taxes that she didn't pay. She was sick, of course, and she wasn't paying attention to these issues. But if she would have sat down with an experienced estate planning attorney, she would have paid attention, she would have satisfied these debts, and her loved ones didn't have to go through the trouble. By April 2022, 4 years after her death, there was still a $5 million debt to the IRS. But they entered into the sons and the IRS entered into an agreement to pay this debt as soon as possible. During these 4 years, Aretha's sons didn't have any access to her money or to her royalties or licenses. They couldn't access anything. The court granted them in 2021 a $50,000 just to cover some of their expenses. At the time of her death, Aretha's estate was worth about $80 million. So not having access to her money, it was a huge headache for her sons. If Aretha Franklin would have created an asset protection trust, her loved ones would have avoided the governmental interference, the huge legal fees, all the court fees, and the headaches and the 4-year delay in accessing her money. The third point is that Aretha Franklin was unable to plan for her family member with special needs, her son Clarence, who's a special needs adult. Because the lack of planning, Clarence will not receive governmental benefits, will not be protected from creditors and predators. This is due to the fact that he is going to receive his inheritance outright from his mother. You see, individuals with special needs require a lifetime of support and assistance, and many times they rely on the government programs to pay for the huge medical expenses they have to incur. If Aretha Franklin would have created a comprehensive estate plan, she would have avoided sending her sons to the courthouse, the surrogate court, would have avoided the government's interference, would have avoided the will becoming public and having anybody find out what her children inherited from her, because a will is public as opposed to a trust that it's private. and it's settled out of court with the privacy that nobody finds out what's in that trust. This is what Aretha Franklin should have done. She should have created an asset protection trust, nominate trustees, trustworthy people for this trust, transfer all her assets to the trust, and nominate her sons as beneficiaries with the creation of a special needs trust for her special needs son. If she would have done that, she would have saved her loved ones 4 years of headaches and battles in court, unnecessary governmental interference. Also, she would have saved her loved ones hundreds of thousands of dollars in legal fees and court fees, and would have preserved their privacy. Getting an estate plan, it's not only for the celebrities and the wealthy, it's for all of us, because all have loved ones that we shouldn't send to court to probate a will. Regardless of your financial situation, planning for incapacity or death is something that you should do immediately. And not wait like Aretha Franklin waited when it was too late to meet with her attorneys. Aretha lived for 76 years, but nobody knows how long they're gonna live, and we don't know when a crisis strikes. We can use Aretha Franklin's life story and lessons learned from her estate debacle, and we can keep our loved ones out of court, out of conflict, and out of the public eye. For the protection of our clients, we created the inheritance audit meeting, when you will find out if you have all the documents in place and whether you are protected or not so much. The inheritance audit meeting is free of charge, and with a free phone call, you will know how protected you and your loved ones really are. I'm Varvara Gokea, the inheritance lawyer. Go ahead and schedule your free inheritance audit now.